Today, the U.S. Supreme Court upheld a ban in Tennessee on gender-affirming care for transgender minors. In a 6-3 decision, Chief Justice John Roberts wrote the law does not violate the Constitution's Equal Protection Clause. In her dissent, Justice Sonia Sotomayor said this decision, quote, abandons transgender children and their families to political whims. 26 states have similar laws to Tennessee's. The ACLU lawyer who argued this case called the ruling, quote, a devastating loss for transgender people.
We think that the court just got it absolutely wrong. And as a material matter, it's devastating for the people who are most affected.
To allow them to make a decision that will affect not only the entire course of the development physically, psychologically, and reproductively is completely ridiculous.
Tennessee's Attorney General called the ruling, quote, a landmark victory for Tennessee at SCOTUS in defense of America's children. Advocates say this comes as states and the federal government are stepping up regulations on transgender people, including in health care as well as in school sports.
Well, joining us now with the key takeaways from today's decision is Jessica Levinson, law professor at Loyola Marymount. Thank you so much, Jessica, for being here. Help explain how the justices reached this decision today and the main factors that they considered.
So the justices looked at this Tennessee law that bars gender-affirming care for minors and said, this is a law that discriminates on the basis of age and medical use. This is not a law that discriminates on the basis of sex or transgender status. I think that was the most important thing legally that the court said, because it leads to everything else that happened next. After you find that this is a law that discriminates on the basis of age, which is not a protected class, and medical use, which is also not protected, it's not something we worry about a lot, then the court decides to use a very low standard of review, not kind of intermediate scrutiny or strict scrutiny, but instead rational basis. If you apply this very low deferential standard of review, then the state law at issue is very likely to be upheld, and that's exactly what happened today. I mean, the big takeaway is the court says that there's no equal protection clause bar to states having the type of law that Tennessee has.
The doctors and the families who brought this initial lawsuit challenging the Tennessee law, along with making the claim about discrimination based on sex and transgender status, they also pointed out that this law allowed for the prohibited treatments for reasons other than for gender transition care. Why do you think an argument like that wasn't enough to persuade the justices here, or persuade enough of them?
Exactly. It did persuade the dissent in this case, the dissents. I think because the justices in the majority just viewed this as through a different lens. They viewed this through the lens of, okay, it bars everybody under 18 from using these types of treatment, puberty blockers and other hormone therapy for the prohibited purposes. And so what the majority here was saying was, it doesn't matter if you identify as transgender or if you don't identify as transgender. If you're under 18, you cannot use these medications for this goal. Now, the dissent said this is discrimination on the basis of transgender status, and we as members of the judiciary need to protect individual rights, and we need to use a higher level of scrutiny. It's fundamentally just a very different view of the same law.
Okay, so what could this decision, this ruling today, mean for bans in states besides Tennessee?
So it means this is a constitutional decision. So it means that under the Equal Protection Clause, Tennessee and any other state can have a law that looks like this one. Now, I keep saying under the Equal Protection Clause because there is another argument, and I think similar laws could be challenged based on a different part of the 14th Amendment, not the Equal Protection Clause, but the Due Process Clause. And I think the argument will be made that parents have a liberty interest in directing their children's medical care. That's not the question for the court today. It's not going to be the question for the court tomorrow. but that's still an open and lingering question.
All right, so we could see similar cases, maybe back in front of the High Court at some point in the future. Let me talk to you about the sort of how we wound up here with this really important ruling today. Initially, it was the Biden administration that fought to block the Tennessee law from taking effect. But then when President Trump returned to office, his administration reversed the government's position and urged the justices to uphold the law. Did that reversal and the change of administration have any bearing on the ruling we saw today from the High Court?
I frankly don't think it did, in the sense that there were still people left to challenge the law, and there were still the parents of minors and the medical providers who were still there making arguments against Tennessee's law. I think, frankly, where it really made a difference that the Biden administration intervened is that the Biden administration, if memory serves, intervened under a federal statute that allowed them to do so to try and vindicate equal protection rights. And that's why that other argument we were just talking about, the rights of parents, that question did not proceed to the court. And I think that obviously made a difference in terms of the shape of the case. About half of the case went up to the court today.
And Professor, what about this decision? What does it mean for states that don't have bans on gender-affirming care?
Really important question. Nothing in this decision says you must have a law like Tennessee's. It says you may. Nothing under the Equal Protection Clause bars you from doing so. So I know that this will be a phrase that people have heard before with respect to other cases. It leaves it to the states. And the idea is, and what the majority was saying is, this is a case where we want policymakers, elected decision makers making these calls, not unelected judges. So it goes back to the states to determine what they want to do.
All right. Great perspective here on a really important ruling today from the High Court. Jessica Levinson, Loyola Marymount University. Great to have you on. Thank you.
Thank you.